slave, you picking that cotton?
Yes, master.
Not fast enough. Oh, ow.
Hey, the 13th Amendment has been passed. Slavery is illegal now. This man is free. Ah!
I'm not a slave anymore, but I still don't have rights.
Don't worry about it, man. The 14th Amendment has been passed.
Really? What does that mean?
You're a citizen now, and African Americans have rights.
Really?
Yeah, congratulations. Bring it in.
Thanks, buddy. Hey, I'm here to vote.
What's the color of your skin?
Black.
What? You can't vote here, black son.
Hey! The 15th Amendment's been passed. Blacks have the right to vote. Get out of here! Hey,
Oh, thanks,
here
buddy.
you go, buddy. Sit down. Vote. Democracy matters. The Civil Rights Act of 1875 was enacted during Reconstruction. It guaranteed African Americans equal treatment in public accommodations, public transportation, and prohibited exclusion from jury service. In 1883, the Supreme Court decided the act was unconstitutional.
Hey, boy, can I vote?
No, you're a woman.
What?
Women can't vote.
Nah. The 19th Amendment's been passed. Women have the right to vote.
The Civil Rights Act of 1964 outlawed discrimination based on race, color, religion, sex, or national origin. It ended unequal application of voter registration requirements and racial segregation in schools, at the workplace, and by facilities that serve the general public.
The Equal Rights Amendment was a proposed amendment to the United States Constitution designed to guarantee equal rights for women. The ERA failed to receive the requisite number of ratifications before the final deadline mandated by Congress, so it was not adopted. Feminist organizations have continued to work at the federal and state levels for the adoption of the ERA.
I got $1. How much money did you get?
I got $5.
What? You can't do that. That's so unfair.
Well, you're a woman. I'm a man.
Hey, that's not right. The Equal Pay Act of 1963 has been passed. Men and women should get the same amount of money for the same job. The Northwest Ordinance was an act of the Congress of the Confederation of the United States, passed July 13, 1787. The primary effect of the ordinance was the creation of the Northwest Territory, the first organized territory of the United States, from the lands south of the Great Lakes, north and west of the Ohio River, and east of the Mississippi River. Hey, Native American.
What do you want?
If you accept allotments and agree to live away from your tribe, you'll be granted United States citizenship. This is due to the Dawes Act.
Okay.
You, sir, are a United States citizen. Say goodbye to your friends.
No. Can't wait to move to America. I'm so excited.
Wait right there.
What?
The Chinese Exclusion Act just passed, and we can't allow you here anymore.
I'm pissed.
Buddy, are you gay?
Don't ask me. If I tell, I'm gonna get discharged from the army.
Or whatever.
Preposition 8 was a California ballot preposition and a state constitutional amendment passed in November 2008 California state elections. The preposition was created by opponents of same-sex marriage in advance of the California Supreme Court May 2008 appeal ruling. In remarriage cases which followed the short-lived 2004 same-sex weddings controversy and found the previous ban on same-sex marriage unconstitutional. Preposition 8 was ultimately ruled unconstitutional by a federal court in 2010, although only confirmed on June 26, 2013, following the conclusion of proponents' appeals.
The Americans with Disabilities Act of 1990 is a law that was enacted by the U.S. Congress in 1990. Senator Tom Harkin authored the bill and was its chief sponsor in the Senate. Harkin delivered parts of his introduction speech in sign language so his deaf brother could understand. The ADA is a wide-ranging civil rights law that prohibits, under certain circumstances, discrimination on disability.
The Civil Rights Cases of 1883 were a group of 5 similar cases consolidated into one issue for the U.S. Supreme Court to review. The court held that Congress lacked the constitutional authority under the enforcement provisions of the 14th Amendment to outlaw racial discrimination by private individuals and organizations, rather than state and local governments.
Oh my god, this bed is so soft and comfortable.
What the heck? My bed is so hard, it's unfair. Why do we have to have different facilities?
You know, in the Supreme Court, Plessy versus Ferguson just happened. They ruled that separate but equal facilities are okay. And these seem to be equal to me.
Just take it!
Mueller versus Oregon was a landmark decision in the United States Supreme Court, as it justifies both sex discrimination and usage of labor laws during the time period, around 1908. The case upheld Oregon state restrictions on the working hours of women as justified by the special state interest in protecting women's health.
Brown v. Board of Education was a landmark United States Supreme Court case in which the court declared state laws establishing separate public schools for black and white students unconstitutional. The decision overturned Plessy v. Ferguson decision of 1896, which allowed state-sponsored segregation insofar as it applied to public education.
In 1955, the Supreme Court considered arguments by the school requesting relief concerning the task of desegregation. That school being County School Board of Prince Edward County. In their decision, which became known as Brown 2, the court delegated the task of carrying out school desegregation to district courts with orders that desegregation occur, quote, with all deliberate speed, end quote, a phrase traceable to Francis Thompson's poem, The Hound of Heaven.
Swan v. Charlotte-Mecklenburg School District was an important United States Supreme Court case dealing with the busing of students to promote integration in public schools. After a first trial going to the Board of Education, the court held the busing was an appropriate remedy for the problem of racial imbalance in schools, even when the imbalance resulted from the selection of students based on geographic proximity to the school rather than deliberate assignment based on race.
I'm having a baby! Can I get an abortion?
Why, of course you can. In the Supreme Court, they said it was all right in Roe versus Wade.
Korematsu v. United States was a landmark United States Supreme Court case concerning the constitutionality of Executive Order 9066, which ordered Japanese Americans into internment camps during World War II, regardless of citizenship. In a 6-3 decision, the court sided with the government, ruling that the exclusion order was constitutional. Reed v. Reed was an equal protection case in the United States in which the Supreme Court ruled that the administrators of estates cannot be named in any way that discriminates between sexes.
Craig v. Boren was the first case in which a majority of the United States Supreme Court determined that statutory or administrative sex classifications had to be subjected to an intermediate standard of judicial review. Hernandez v. Texas was a landmark United States Supreme Court case that decided that Mexican Americans and all other racial groups in the United States had equal protection under the 14th Amendment of the United States Constitution.
League of United American Citizens v. Perry is a Supreme Court of the United States case in which the court ruled that only District 23 of 2003 Texas redistricting violated the Voting Acts right. The court refused to throw out the entire plan, ruling that the plaintiffs failed to state a sufficient claim of partisan gerrymandering. The opinion requires lawmakers to adjust congressional district boundaries and comport with the court's ruling, though the ruling does not threaten Republican gains as a result of the redistricting in Texas.
Wall v. Hopkins was the first case where the United States Supreme Court ruled that a law that is race-neutral on its face but is administered in a prejudicial manner, is an infringement of the Equal Protection Clause in the 14th Amendment in the United States Constitution. Romer v. Evans is a landmark United States Supreme Court case dealing with sexual orientation and state laws. It was the first Supreme Court case to address gay rights since Bowers v. Hardwick, when the court had held that laws criminalizing sodomy were constitutional.
Lawrence v. Texas is a landmark decision by the United States Supreme Court. In a 6-3 ruling, the court struck down the sodomy law in Texas and, by extension, invalidated sodomy laws in 13 other states, making same-sex sexual activity legal in every U.S. state and territory. The court overturned its previous ruling on the same issue in 1986 case Bowers v. Hardwick, where it upheld a challenged Georgia statute and did not find a constitutional protection of sexual privacy. Tennessee v. Lane was a case of the United States Supreme Court where the plaintiffs were disabled Tennesseans who could not access the upper floor of the state courthouse. The plaintiffs argued that they were being denied services because of their disabilities. In a 5-4 split decision, the Supreme Court ruled that the disabled were being denied fundamental rights that are protected by due process clause of the 14th Amendment, among those rights being the right to access a court. University of California versus Bakke was a landmark decision by the United States Supreme Court. It upheld affirmative action allowing race to be one of the several factors in college admission policy. However, the court ruled that specific quotas, such as the 6 out of 100 seats set aside for minority students in the University of California Davis School of Medicine, was impermissible. Grutter v. Bollinger was a case in which the United States Supreme Court upheld the affirmative action admissions policy of the University of Michigan Law School. The court held that a race-conscious admissions process that may favor, quote, underrepresented minority groups, end quote, but that also took into account many other factors evaluated on an individual basis for every applicant, did not amount to a quota system that would have been unconstitutional under the University of California versus Bakke decision.
Gratz versus Bollinger was a United States Supreme Court case regarding the University of Michigan undergraduate affirmative action admissions policy. In a 6-3 decision announced on June 23, 2003, Chief Justice Rehnquist, writing for the court, ruled the university's point system's predetermined point allocations that awarded 20 points to underrepresented minorities ensures that the diversity contributions of applicants cannot be individually assessed and was therefore unconstitutional.
Blow out world star before rap. You already know that. So fresh Prince, they are about to bring the show back. Listening to Kilo, weekend cost a kilo. Hair so long, I'm about to bring the flow back.